In the quiet, unassuming college town of Moscow, Idaho, a crime of unimaginable horror shattered the peace and captured the anxious attention of the entire nation. The brutal, senseless murders of 4 promising University of Idaho students, Madison Mogen, Kaylee Goncalves, Xana Kernadle and Ethan Chapin, left a close-knit community utterly devastated and a country starving for answers and for justice. Now, just as it seemed the slow wheels of the legal system were finally beginning to turn, a startling new development threatens to grind the entire process to a screeching halt. The man accused, the man at the very center of this storm, Bryan Kohberger, and his determined defense team have just made a legal maneuver that has left everyone from legal analysts to the victims' families, asking one overriding question. What are they truly trying to hide? The defense has officially filed a motion to delay the trial, the very same trial that the heartbroken families of the victims have been waiting for with bated breath. Their stated reason? They claim they need more time, much more time, insisting that a fair and just trial is simply not achievable under the current schedule. But is this a standard, textbook legal strategy employed in a complex case, or is there something much more calculated happening behind the closed doors of their war room? Something strategic that the defense doesn't want the prosecution or the public to see just yet? The prosecution has a name for this approach, and it's a grim one: a scorched earth strategy. The judge, while he has not yet made a final, binding decision, has sent a powerful and clear signal to both sides, stating it's likely you're going to trial on the date indicated. This declaration has set the stage for a monumental legal showdown, a high-stakes chess match where every single move, every filing and every argument could be the one that finally unlocks the truth. The very foundation of the defense's argument is a straightforward, yet incredibly heavy claim: they are overwhelmed and unprepared to proceed. Ann Taylor, Bryan Kohberger's lead defense attorney, has been unwavering in this position, stating emphatically in court, "We are not prepared to go to trial in this case." In the context of a capital murder trial, where the ultimate penalty is on the table and a man's life is literally on the line, that is a profoundly powerful statement. Their argument for this delay is built on 2 main pillars: the staggering, almost incomprehensible amount of evidence and the constant, pervasive and potentially biasing media coverage that has saturated this case from the very first day. Attorney Taylor described the discovery evidence as vast, portraying it as a digital mountain of information that her team is still struggling to climb. "I received discovery just last week. It is discovery that I have not reviewed yet," she confessed to the judge, underscoring the fact that new, potentially crucial information is still trickling in, even at this late stage. This process isn't just about passively reading documents. It's about meticulously analyzing every single photograph, deconstructing every digital file, and scrutinizing every piece of forensic data with an incredibly fine-toothed comb. The defense claims they are grappling with a mind-boggling 68 terabytes of evidence. To truly put that into perspective, a single terabyte can hold hundreds of thousands of high-resolution photos or countless hours of HD video. Sifting through that volume of data isn't just a task. It's a monumental, almost superhuman undertaking. It isn't just the digital evidence posing a challenge either. The defense reports that they are also running into significant roadblocks on the human side of their investigation. They've encountered serious difficulties in securing interviews with potential witnesses, a fundamental component of building any robust defense. People are reportedly reluctant to talk, perhaps intimidated by the case's international high profile or simply terrified of becoming entangled in a legal morass that has the entire world's attention. And then, looming over everything, is the specter of the death penalty. With prosecutors seeking the ultimate punishment, the stakes could not possibly be higher. In a capital case, the defense is burdened with a dual responsibility. First, they must argue for their client's innocence during the guilt phase, and second, if he is convicted, they must present a compelling case for why he should be spared the death penalty during the sentencing phase. This second part, known as mitigation, requires them to dig deep into every facet of Bryan Kohberger's entire life story, a process that Ann Taylor argues is a non-negotiable constitutional requirement when the government is attempting to extinguish human life. She forcefully claims the current trial schedule, which she has labeled excessively fast, simply does not afford them enough time to conduct this constitutionally mandated investigation properly. For the defense team, this isn't merely about procedural rules or courtroom etiquette. It's about fundamental, inalienable rights. They firmly believe that proceeding to trial in August would be a direct violation of Bryan Kohberger's constitutional right to a fair trial and his right to be represented by effective legal counsel. Taylor has gone so far as to say she cannot ethically or properly defend her client if the trial happens as planned, A stark statement that feels like it could be laying the preliminary groundwork for an inevitable appeal should they lose this critical fight over the trial date. Compounding the defense's challenges is the relentless, blinding glare of the media spotlight. From the second the tragic news broke, this case has become a powerful magnet for public obsession, armchair detective work, and rampant speculation. The defense contends that this is not just harmless background noise. They argue it is a toxic force that has effectively poisoned the well from which they are required to find an impartial and unbiased jury. And Taylor has pointed directly to the highly inflammatory and ubiquitous media coverage as a primary justification for needing a delay. The pervasive fear is that the ceaseless torrent of news reports, sensationalized documentaries, and unfiltered online commentary has already cemented a narrative of guilt in the public consciousness, making it nearly impossible to find 12 individuals who have not already formed a firm opinion about Bryan Kohberger. This problem was dramatically exacerbated by a series of damaging leaks. A recent episode of the popular news program Dateline on NBC aired specific details about the ongoing investigation that had not been previously released to the public. The court has expressed suspicion that this sensitive information likely originated from someone who was bound by a strict judicial gag order. The defense alleges that these leaks are not accidental slips but appear to be carefully curated to promote a narrative of guilt, a bombshell accusation that directly challenges the fairness and integrity of the entire investigation. This Dateline issue, as Taylor referred to it, is not being treated as an isolated incident but as part of a disturbing pattern of media disclosures that she insists is systematically destroying the possibility of a fair trial. The defense has taken the extraordinary step of asking for a special investigator to be appointed for the sole purpose of identifying the source of these leaks, a move that clearly demonstrates just how seriously they view this breach. They believe the very integrity of the legal process is hanging in the balance, and the media frenzy shows no signs of abating. A forthcoming book by the best-selling author James Patterson and a new docuseries on Amazon Prime are both poised to be released, which could flood the public sphere with even more details, theories, and potentially prejudicial information about the case. The defense argues that this unrelenting media blitz makes the task of finding an unbiased jury an uphill, if not utterly impossible, battle. The prosecution, as one would expect, holds a starkly different and uncompromising view. They are vigorously fighting against any further delays, arguing that justice for the 4 victims and their grieving families has already been postponed for far too long. Lead prosecutor Bill Thompson's position is crystal clear and resolute. It is time to try this case. From the prosecution's perspective, the defense has been afforded more than enough time and resources to prepare their case. They are quick to highlight that Bryan Kohberger was arrested all the way back in December of 2022 and was formally indicted in May of 2023. They argue that the defense has been provided with more than adequate legal support and has successfully met all of its court-mandated deadlines up to this point, which the prosecution presents as de facto proof that they are, in fact, ready to proceed to trial. Special Deputy Prosecutor Joshua Hurwitz has gone a step further, accusing the defense of employing a scorched earth strategy, essentially asserting that their numerous motions and pleas for more time are nothing more than a calculated effort to stall the proceedings. He believes the defense is weaponizing the large volume of evidence and the issue of media leaks as a convenient excuse for a delay they have been planning all along. Hurwitz even suggested that this push for a delay is a new tactic that the defense pivoted to only after they were unsuccessful in their attempt to get the death penalty taken off the table. A scorched-the-earth investigation is not what's required, Hurwitz stated, directly challenging the defense's assertion that they are constitutionally required to investigate every remote corner of Kohberger's life before the trial can begin. The prosecution also remains unpersuaded by the defense's anxieties about pretrial publicity. They contend that delaying the trial will do nothing to diminish the media attention. In fact, it might even make it more challenging to find an impartial jury later on as public interest continues to fester. As prosecutor William Thompson Jr. pointedly asked in court, "Every time there's a new book or a new documentary, are we going to continue the trial indefinitely?" The prosecution is expressing full confidence that the court's established jury selection process, known as voir dire, is robust enough to filter out biased individuals and guarantee a fair trial, even in the face of intense media scrutiny. They point to the recent Lori Vallow Daybell trial, another highly publicized and complex case handled in the very same courthouse, as tangible proof that a fair jury can be seated. Ultimately, the prosecution's argument consistently returns to the victims. They repeatedly remind the court that the victims' families have a constitutional right to see this case resolved in a timely and expeditious manner. For them, Every delay represents another painful chapter in an already unbearable story of loss and grief. They have waited long enough for justice, and the prosecution is fiercely determined to ensure they get it without any more waiting. All of this intricate legal maneuvering and strategic posturing leads us to the million-dollar question that looms over these proceedings. What is the defense really up to? Is this just a standard, by-the-book attempt by diligent lawyers to ensure their client receives every protection the law allows? Or is there a deeper, more calculated and hidden strategy at play here? One of the most tantalizing possibilities revolves around the defense's cryptic mention of alternate perpetrators. They have claimed in court filings to have discovered evidence within the prosecution's own discovery materials that points to the possibility of someone else being responsible for these horrific murders. This isn't just a wild, unsubstantiated theory thrown out to create chaos. The defense has submitted their purported evidence to the judge under seal, meaning it is shielded from public view and has only been discussed behind the secure fortress of closed doors. The judge has reportedly questioned whether what the defense has presented so far is substantial enough to even be admissible in court, suggesting it might be more smoke than fire. But the defense is tenaciously clinging to this angle, and a significant delay would grant them the invaluable time needed to investigate it more thoroughly, to potentially find more corroborating evidence, and to build a truly convincing case that someone other than Bryan Kohberger is the real killer. Another critical focus for the defense is, naturally, the evidence stacked against their own client. They have filed a barrage of motions seeking to suppress key elements of the prosecution's case, such as the digital data from Kohberger's phone and vehicle, and most critically, the DNA evidence that supposedly links him directly to the crime scene. They are aggressively challenging the methods and legal justifications used to obtain the search warrants, a strategic move that, if successful, could completely dismantle the prosecution's case. A delay would give their experts more time to prepare for these make-or-break suppression hearings, to meticulously pick apart the police investigation, and to find any procedural errors or constitutional violations that could get the most damning evidence thrown out of court. Then there is the enormous task of the mitigation investigation for the death penalty phase. This is an exhaustively detailed and time-consuming job, and the defense may be using the genuine need for more time as a powerful strategic card to play. They even subtly hinted that they could be ready for the original trial date if the death penalty were taken off the table, a suggestion the prosecution likely views as a strategic bluff. A delay allows the defense to construct a fuller, more empathetic narrative of Bryan Kohberger's life, a story meticulously designed to persuade a jury that even if they find him guilty, he is not a monster who deserves to be executed. This could involve exploring his family history, his psychological background, his social development, and anything else that might humanize him in the eyes of a jury. Finally, the delay itself may be the ultimate strategy. By dragging out the pretrial phase, the defense can continue to chip away at the prosecution's case, file an endless stream of motions, and hope that the passage of time will cause witnesses' memories to fade or that new, exculpatory evidence will miraculously surface. It also gives the intense public anger and desire for retribution a chance to cool, which could potentially make it easier to find a more sympathetic jury pool down the road. In a case of this magnitude, time itself can be a formidable weapon, and it appears that the defense is using every legal tool at its disposal to wield it to their advantage. The prosecution's scorched earth accusation powerfully suggests they do not see this as a noble search for fairness, but as a grueling war of attrition. The contentious fight over the trial date in the Bryan Kohberger case is far more than a simple squabble over scheduling. It is a revealing look deep inside the complex strategies, immense pressures, and competing interests that are shaping one of the most intensely watched criminal cases in recent American history. On one side, you have a defense team passionately arguing that the very concept of a fair trial is on the brink of collapse. They point to a mountain of evidence they have yet to fully review, key witnesses who are unwilling to speak, and a media climate so thick with a presumption of guilt that finding an impartial jury feels like an impossible task. They insist that in a death penalty case, the U.S. Constitution demands a level of meticulous thoroughness that the current schedule simply does not permit. On the other side, you have a prosecution team that is putting its foot down with equal force, declaring that the time for delays is definitively over. They accuse the defense of waging a scorched earth campaign, of fabricating reasons to stall what they see as a war of attrition. They maintain that justice for the 4 young victims and their grieving families demands that the process move forward, and they are confident that the system is fully capable of providing a fair trial, even under the glare of the international media spotlight. Caught in the middle of this high-stakes tug-of-war is a judge who must carefully balance the defendant's sacred constitutional rights against the rights of the victims and the state's legitimate need to proceed with justice. While he has hinted that he is leaning toward maintaining the current trial date, the final, official decision has not yet been handed down. That decision will not only set the timetable for everything that is to come but will also send a powerful signal about how justice functions when it is placed under a global microscope. The ultimate question of what the defense is truly hiding, whether it's a bombshell theory about an alternate suspect, a fatal flaw in the prosecution's case, or just a desperate need for more time, will continue to fuel speculation as this tragic and profoundly complicated case moves ever closer to its inevitable and surely emotional conclusion.